Prenuptial agreements and inheritance rights. How courts take care of your spouse after you're gone. A prenuptial agreement and an estate plan can be woven together into a formidable legal package to protect your property and your loved ones, but there are a few twists you need to know. Watch this show to find out how a prenup can be a powerful estate planning tool, especially when it comes to limiting a surviving spouse's rights to inherit. Familiarize yourself also with the rights of a surviving spouse and see how a prenuptial agreement can affect those rights. Welcome back, folks, to another edition of Sweetie Kiwi. How you doing today? I hope you are doing fantastic. I'm doing marvelous, if you were to ask me. If you are doing as terrific as I'm doing, please go grab a cup of coffee or tea or vodka. Let's roll. Today I want to talk to you about prenuptial agreements and inheritance right. How courts take care of your spouse after you're gone. Now let's first talk about a surviving spouse's right to inherit. In every state, the law protects the property rights of surviving spouses. Historically, though, the goal of this laws from New York to California has been to prevent a non-earning spouse from being left with nothing at the death of the earning spouse. So the authorities have tried to create some kind of legal and moral and ethical balance, financially speaking. So to provide this protection, states will take one or two approaches depending on whether the state is a quote-unquote common law or community property state. I'll just break that down a little one for you. So common law states give surviving spouses the right to inherit property, while community property states provide spouses rights to their partners earn property during life. During life is important. So a prenuptial agreement, also called a prenup, as you know, can be very useful in both situations, common law and community property scenarios. Let's talk now about elective share, a spouse's right to inherit property. And I'm going to break it down from when it comes to common law versus community property laws, community property states, rather. In common law states, without a prenup, your spouse has the right to inherit property from you when you die. This is true even if you had a valid will, no matter the terms of the will. This is so critical, folks. I'm going to repeat it. In common law states, without a prenuptial agreement, your spouse has the right to inherit property from you when you die. This is true even if you had a valid will, no matter the terms of the will. So if you're trying, for instance, to disinherit your spouse by leaving your spouse little or nothing through your will, after your death, guess what? Your spouse can still get something. He or she will have two options. Either take the property you designated in your will or take the elective share. And I'm going to explain the elective share now, because this is something that a lot of our viewers have asked in the last few weeks, and we're just going to break it down. Now, an elective share is the minimum amount to which a spouse is entitled under state law. It is usually the same amount provided to spouses under intestacy laws. Intestacy is a process that applies when there is no will. Intestacy, so intestacy. The amount is generally a set fraction. It could be 20%, 30%, or 50%. Typically 1/3 or 1/2 of the deceased spouse's estate, but the amount may vary on the length of the marriage and whether there are children involved. So, assuming you live in a common law state and your will doesn't leave your spouse at least the amount of the elective share, your spouse can choose to take the elective share amount instead. When this occurs, your spouse will end up with more of your property than you intended, and other beneficiaries will end up with less. Let's now talk about community property, because I was talking about common law with the elective share. Now let's talk about community property, a spouse's right to own property during the marriage. In a community property state, without a prenuptial agreement, your spouse has the right to an equal 1/2 share in all income and assets acquired during the marriage. There are two important keywords here, folks. First, we have 1/2 share, so that's 50%. of all income and assets acquired. And the second keyword here is during the marriage. So nothing before. If you've been married for 40 years, any income and assets that have been accumulated during that 40-year, that 4-decade time period will be split in half. You can designate how your separate property is given away after your death. So separate property in community property states includes gifts, inheritance, and property you owned before you got married. So you can dispose of your 1/2 of all community property in your will or other estate planning documents, but you cannot dispose of your spouse's share without his or her permission unless your prenup gives different instructions. This is why a lot of newlyweds or a lot of couples throughout the country will have lawyers write the prenup. Actually, it's very common to have 2 lawyers, one for each partner, one for each spouse, to draft a prenup, and have both lawyers now trying to find the common denominator of both prenups. That way, both spouses are comfortable that their wishes and preferences are taken into account when it comes to having the final, the compromise, the consensus prenup. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Kiwi. We are still talking today about prenups and inheritance rights, how courts take care of your spouse after you're gone. And if you love the clarity and quality of the content so far, please consider subscribing to our channel and turn on the notification bell so you can be informed in real time whenever we drop a new show. I want to talk to you today now about prenuptial agreements and state property laws. One thing you have to understand is that prenuptial agreements trump state property laws. So in a prenup, spouses can decide who owns what and what property rights each spouse will have after the death of the other. So those choices are made and agreed to in a prenuptial agreement, and those choices override the laws designed to protect a surviving spouse. So typically, under a prenuptial agreement, elective share and community property laws don't apply. Let me give you an example, a very simple one. Let's say you want to leave the majority of your estate to children from a prior marriage, and say you want to leave 80% of your estate to children from a prior marriage, and say 10% to your spouse. Your spouse can agree to waive the elective share in a prenuptial agreement. He or she can do that. So you can also use your prenuptial agreement to decide which of your assets are separate property and which are marital or community property. Now, it is very key here. It is seminal. It is critical to understand that such an agreement will change your spouse's right to inherit that property when you die. Similarly, you and your spouse could use your prenuptial agreement to waive your rights to each other's retirement accounts. Essentially, what I'm trying to say here is that a prenuptial agreement and all the clauses and provisions indicated in that agreement trump state property laws. So the agreement can state that the income earned by a spouse is that the spouse's separate property, thereby nullifying the default rule in community property states. So the idea here is that, folks, again, there are 2 things I want to indicate here. Number one, we're not giving any legal advice here, right? This is a general conversation around prenuptial agreements and inheritance rights. We have conducted research and we are giving you the results of that research. So that's the first point, aka a disclaimer. So if you need specific advice, if you need specific knowledge, and this is the second point, you want to contact a lawyer in the area where you live. You want to contact someone who has experience with estate planning, and that person and that lawyer, that attorney can help you, can guide you better when it comes to protecting your rights. What I'm trying to say here is that anything you put in a prenup will trump state property laws. So be very careful about what you agree to before marriage, or be very careful about your priorities in a prenup, because whatever you have there will have authority, will have preeminence over basic state laws. I also want to talk about the requirements of a prenuptial agreement. We've been talking about the fact that a prenup is very important, carries a lot of weight legally and socially and financially. Let's now dig a little deeper into the requirements of a prenup. What makes a prenup valid? What makes a prenup sound? These are some common requirements for making a valid prenuptial agreement. Both spouses must voluntarily agree to the terms. In other words, there shouldn't be any undue pressure, any duress. We want to have people should be voluntarily agreeing to the terms and provisions and clauses in the prenup. Both spouses must provide full and accurate financial disclosures. No partner, no spouse should hide any income if the man has an account in Acapulco or in a tax haven, he must disclose it. If the woman has some inheritance somewhere, she must disclose it. Both spouses must have the opportunity to seek independent legal counsel. This is what I was just saying earlier, that it is very common to have two lawyers, each representing each partner, each spouse, sitting down and drafting a common document, a final document that is in essence the common denominator of the preferences and the wishes of both spouses. And the agreement must be fair. So 4 essential requirements for making a valid prenuptial agreement. Both spouses must voluntarily agree to the terms. They must provide full and accurate financial disclosures. They must have the opportunity to seek independent legal counsel, and the agreement must be fair. So if your spouse, for instance, contests a prenup, the court may consider procedural and substantive fairness to determine if the document should stand. Let me just break down what procedural fairness and substantive fairness mean. Procedural fairness is about timing and logistics, like whether your spouse had a sufficient amount of time to review the agreement before signing it. If the bride was given a prenuptial agreement on the eve of the wedding, for example, a court may conclude that she signed it under duress, under pressure. So that's procedural fairness. So the courts wants to make sure that the procedure was fair. The procedure that led to the signing of the prenup was fair. Now let's talk about substantive fairness. Substantive fairness is generally about whether the terms of the prenuptial agreement were fair to both spouses. So states are very different as to whether the agreement only needed to be fair at the time it was made, or whether the agreement must also be fair at the time that it is applied, such as at divorce or death. So you have two timestamps here, folks. You have when the agreement was made originally at time T, and when the agreement has to be applied at time T plus 20 or time T plus 30 years at divorce or death. So if a prenup essentially would cause a spouse to become impoverished, it is unlikely to be upheld in court. So the laws that govern prenuptial agreements are state specific and very nuanced, and you will need a lawyer's help to make one. Having said that though, you and your partner can work together to draft your own agreement before you go to a lawyer. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Kiwi. I hope you're still here with us. If you love the clarity and the quality of the content so far, please consider subscribing to our channel, like this content, share, and most important, ask questions. Comment below. Let us know your opinion. If you have questions, our team will answer to the best of our ability every question you ask if it is relevant to the topic discussed. Now, do you still need an estate plan? We are talking now about a prenuptial agreement. A prenuptial agreement can affect how your property is distributed after you pass away, but it is not an estate plan and it's not a substitute one. Rather, your prenuptial agreement should work in conjunction with your estate plan. For instance, your prenup can determine which of your property is separate property. Then your will or trust determines who gets that property when you die. This is critical, folks. I'm going to repeat that. Both documents should work in conjunction. So your prenuptial agreements should work in tandem with your estate plan. For instance, your prenuptial agreement can determine which of your property is separate property. Then your will or trust determines who gets that property when you die. Similarly, you might have your prenuptial agreements waive your spouse's right to the elective share, and then have your will or trust state that your spouse should get specific items out of your estate. Additionally, and we've seen this from New York to California, all across the country, a lot of spouses can have their estate plan do many things that the prenup agreement cannot do. It really boils down to what? To your personal situation, to your family situation, to the kind of property that you have, whether you have big ticket items such as real estate, stocks, bonds, 7-digit portfolios, whether you have collectibles, whether you have valuables, or whether your portfolio is kind of small. So that's what's going to dictate your moves here when it comes to estate planning and prenup signing or prenup planning. So one thing you really want to do is to use your estate plan to determine who gets your property when you die, to name your executor. You can also appoint a guardian for your young children. You can decide who can make financial and medical decisions on your behalf. You want to document your end of life or emergency healthcare wishes. And this is a critical element in the estate plan, the end of life or emergency healthcare wishes. And by doing that, you can also nominate the person you want to be your emergency contact. We just finished a show about emergency contacts, what really matters in appointing someone. And you can also use your estate plan to essentially provide final arrangements for burial, cremation, funeral, memorial, and so on. All right, folks, this is the end of today's conversation. I really appreciate your attention. Here is a quick recap of today's conversation. We were talking about prenuptial agreements and inheritance rights, how courts take care of your spouse after you're gone. And I was talking to you about a surviving spouse's right to inherit. So talked about elective share, a spouse's right to inherit property, and community property, so a spouse's right to own property during the marriage. I also talked about prenuptial agreements, the fact that those agreements will trump state property laws. They have legal preeminence over state property laws, the requirements of a prenup, and the fact that in all of this, you still need an estate plan, because the estate plan does way more than what's included in a prenup. I will see you next time. But until then, remember, stay moralized.